Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the video suggests, this is a follow-up video to another video we did with respect to Trump tax specifically. This is a fairly new piece of legislation. In fact, it's, in relative terms, it's quite a new piece of legislation, having only been promulgated back in December of 2017. At the time of this filming, we're in early March of 2018, so this is fairly new. Everyone is simply getting adjusted to this and trying to understand as best we can how this is going to operate moving forward. That being said, I'm trying to provide as much information as I can based on the research and based on the information I've come across as of the time of this filming. Nothing in this video should be taken as definitive with respect to this issue, and moving forward, I think it's pretty safe to say that we're going to be looking at this could be interpreted a million different ways by not only regulators but courts. So, what I'm saying now may not be very reflective of how this legislation is being put into practical use, say 3 to 5 years down the road. We simply don't know, how this is going to work. I'm simply trying to provide as much insight as I can in sort of an overview nature for those who are interested in these topics, so that they can basically gain a little bit of insight. So some interesting stuff with respect to the international component of the Trump tax legislation, which, as I've read through it, especially the raw law, there's only about 40 pages specifically on international stuff. That being said, that can be a lot, especially with respect to how it can be later interpreted, et cetera, et cetera. Notwithstanding the fact that I believe there's 1,100 pages of the enacted legislation. 40 pages may not seem like much, but in terms of raw law, you can get a lot of stuff in there. Just some highlights that I wanted to bring to people's attention in this sort of update, and we're going to continue doing updates. There's other videos specific to certain aspects of deemed repatriation, as well as the GILTI provisions, the GILTI, as well as the GILTI provisions, the intangible tax, if you will. We did other videos on those topics. I urge those who are watching this video to check those out on this channel. But some things to just take away out of this video. Essentially, the net result of Trump tax is, in an international context, is moving to what's been called a quasi-territorial system with 100% dividends received deduction. So as I read it right now, an onshore incorporated entity that takes dividends from an offshore incorporated entity. So for example, let's say you've got an onshore incorporated entity. I'm just picking this out of the air. Let's say Apple Incorporated in the United States, and they go ahead and pull through dividends directly as a shareholder in, say, Apple Thailand. Okay, I have no affiliation with Apple whatsoever. This is simply just a hypothetical, and they pull through dividends in that manner directly. In the past, there could be significant tax ramifications for that. Moving forward, it seems at least to me, as though that behavior is being encouraged by this tax system, and for that reason, it looks to me like the tax ramifications are going to at least be far more mitigated compared to times past in situations similar to that just described. However, moving forward, it remains to be seen just exactly as a practical matter how this is going to operate. So we'll keep you updated as we see it. This is interesting. One-time tax on previously, one-time tax on previous retained earnings that were not, quote unquote, repatriated back to the United States. So basically, sorry if I have to take a minute to pause because I have to gather my thoughts. Basically, from 86 up to now, 1986 up to now, you could have an entity that had, say, retained earnings that were just kept in the offshore entity and not in, say, a natural American citizen's name, but just like a foreign-controlled corporation that's controlled by an American citizen, and you've got retained earnings in that entity. It would appear that there's going to possibly be some tax ramifications for maintaining a reservoir of retained earnings. As I see it, it may be 8% depending on, or 15.5% depending on what kind of retained assets those are. So, for example, cash seems to be 15.5%. I'll get into that a little bit more in the video on so-called deemed repatriation and retained earnings, etc. But this is a major change. Again, since '86, retained earnings in an offshore entity, it was maybe possible to at least defer tax on those, or perhaps not have to deal with tax on them at all, because they weren't in the United States, they were in an offshore entity, and you didn't really need to deal with them. Again, I don't want to get into specifics on this stuff. I'm just trying to provide an overview. There seems to be a lot of so-called anti-base erosion provisions in this new rule. There's also, it seems to be part of the provisions of this new legislation are trying to push so-called intangible income back onshore, or back onto the, for lack of a better term, the balance sheet of an American citizen abroad. So if an American citizen has like a small foreign corporation, I don't know necessarily that they've crafted it to go after these people necessarily. I think it's more in a medium to large size sort of business environment. It's not really for the quote unquote little guy, but it's going to have a substantial impact on the quote unquote little guy because the way this stuff has been set up. Basically, in the past, you could have an offshore entity that didn't necessarily make a lot of income per se, or at least on paper wasn't making a lot of income, but one could surmise that it had a lot of intangible income, for lack of a better term. And it seems that this act, just as a general provision, or just as a general rule, is seeking to go ahead and at the very least try to get these intangibles onto the books as much as possible, or disclosed up as much as possible, so they can get a better idea of where that sits. Failure to do that could result in some tax ramifications, even for an American overseas, or an American company, or controlled foreign corporation overseas. Those are kind of the basics of how I see the big changes playing out with respect to Americans abroad, with respect to Trump tax. Those are kind of the basics with respect to Americans abroad with a company. The first part one of this sort of two-part video, really pertained to individuals abroad. The second video, sort of in closing, the second video, the thing to take away from it is there's going to be a lot of provisions in the Trump tax, as I see it, that are going to have a substantial impact on American citizens with companies overseas. And it's going to impact a pretty wide spectrum, because it looks to me like anybody that's got a foreign shareholding of 10% or more is going to be impacted by this. It may not be a huge impact, especially for those who are U.S. citizens operating abroad, but they're operating, a business that doesn't make a great deal of money, and they've been, filing their taxes, and it's just not, a big deal. But again, retained earnings are an interesting aspect of some of the changes to the law. This GILTI, G-I-L-T-I, these intangible taxes, if you will. It looks to me like they're trying to pierce through and get a better idea of entities that Americans are using overseas that have a lot, are murky, for lack of a better word. They're sort of opaque with respect to sort of where the company's assets end and where the American citizens' assets begin, or earnings begin. And for that reason, they've created a system that, in my opinion, is going to incentivize better disclosure in an effort to go ahead and mitigate tax liability, especially on things that in the past you could just sort of, for not fudge the numbers, but just sort of didn't really have to overly worry about. And now, again, I'm speaking from a perspective of not necessarily a large multinational corporation, because that's not how they're thinking, but just sort of from the perspective of a small, one-man band operation where, you've got just one single entity abroad. How is GILTI going to affect that individual? It's hard to say, especially where that individual makes a lot of their money in cash, etc. GILTI could have a tremendous amount of impact, especially individuals that have maintained large reservoirs of retained earnings that can have a substantial impact on those individuals. So we'll keep you posted as things progress on this channel and try to provide at least some basic insight into how this operates. Again, another thing to take away from this video, those who think that they have issues with respect to the topics I've just brought up, I strongly, strongly advise you to contact a legal or tax professional in order to get some further insight into these matters, in order to place oneself in the best position and to provide in order to place oneself in the best position and best postured legally, and also to try and mitigate as many obligations or liabilities in as legal a manner as possible.